Okay, cool. So, welcome back. This is the second session that's being offered by the Media Law Resource Center today. We're going to be talking about copyright digital media law. My name, for those of you who might have missed it earlier, is Jeff Hermes. I'm the Deputy Director of the Media Law Resource Center. The MLRC is the leading trade organization in the world for media attorneys. So we work with attorneys representing media clients directly, both at law firms and in in-house practice and in other kinds of settings, educating them, keeping them abreast of what's going on around the world in terms of media law developments, helping them be better attorneys, helping them help each other to be better attorneys, and sort of advancing the cause of First Amendment rights and media rights by helping the people who are on the ground day-to-day fighting those fights. And we have a charitable sister organization, the MLRC Institute, which is dedicated towards sharing the same kind of information with the public and with journalists. And it's under the auspices of the Institute with a grant from the Knight Foundation that we're here today. With me is Sam Pfeiffer from Denton's.
Denton's, yes. Denton's is a law firm you may not have heard of. It's we're a global law firm, and I think we have the dubious distinction of being the world's largest law firm. And all that means is we have the biggest headcount. It doesn't necessarily mean anything more than that, although my partners would argue with me about that. Do you want to flip back a slide just to make sure that we recognize the generous grant from the Knight Foundation? I know that they like to hear those words.
Over and over.
Yeah, I've done other presentations that were endowed by the Knight Foundation, and seriously, they're terrific. And there's a lot of things we couldn't do without them. So we want to thank them for their help with them. So, all right. So given that you've got something that's prepared by lawyers,
sooner or later you're going to get a slide like that.
It's a disclaimer. It's like, hey, you're on your own. We're not giving you legal advice. If you want legal advice, I have a business card and I can hand it out to you, or you can look me up on the internet, or Jeff as well. Clearly don't rely on anything that we tell you not because it's wrong, but because you never know, and we don't want to get sued.
Right. So we're talking general areas of law. During this, feel free to ask questions as we roll.
Yeah.
But if you start asking about very specific situations and asking about advice about your particular issues that you are facing right now, we might well say something like, well, the general rule around this is this, but you really need to talk to a lawyer because facts matter. And this is something that is going to be huge when we talk about copyright. Right. This can be very factually specific, and we'll call that out as we talk.
No, that's right. And what we might do is sort of defer answering your question, because we'll say, we have a slide that covers that. And, we've both been to these kinds of rodeos before, and one of my favorite questions is, I have a hypothetical question involving a trash removal company, and it's like, all right, come on, you're working on that right now, right? We can smell those, usually. Not always, but most of the time we can. So let's start with this question here. What's the difference between copyright infringement and plagiarism? How are they similar? How are they different? You might have an answer for that, and we sort of have an answer for that. And one is really more of a qualitative, breaking of a certain kind of rule, and the other is a little more definite in terms of its statutory and the product of hundreds of years of legal decisions. Plagiarism essentially is, you use somebody else's material without acknowledging that somebody else wrote it. If you ask Joe Biden, he can do 20 minutes on plagiarism, because that's what kicked him out of the 1988 presidential race. And the truth is, he probably didn't do it. He probably had a staffer who copied the Neil Kinnock speech, but he had to wear it because it was the whole idea of command. Copyright is a little bit different. Copyright protects expression. It doesn't protect ideas, and it's actually rather simple in that regard. We'll get into some more of that in some more detail. One thing I want to say though about copyright law. Why do we have a copyright law? Why do we have a very massive statutory scheme that's been around really since 1790. I think it's as old as the United States Marine Corps, and every bit as durable. It's because the Constitution actually expressed a goal of the framers that they charged Congress to come up with a regulatory scheme, actually more than one regulatory scheme, to encourage writers and inventors to write and invent. Now, why would they want to do that? So you have a fledgling republic that is going to be dependent upon, in some regard, to the inventions of the mind, right? I mean, you had an agricultural set of colonies at that point. Agriculture was primary. You were really at the dawn of the Industrial Revolution. And here you had this attention being paid to products of the mind. And I have to say, you know, you've got to tip your cap to the drafters to have instigated the development of these various statutory schemes to create the incentive to create things. And it's really been great fun for lawyers ever since. I mean, that's not why they did it, but it's been really terrific.
And if I can jump in on that, you know, what Sam is saying is really important here. And you might have listened to what Sam said and thought, well, okay, great. Copyright is supposed to sort of encourage this life of the mind. We've also got the First Amendment, which is supposed to encourage discussion, sharing of ideas. And so you've got these two schemes, which in some ways are very similar and have a similar purpose, to encourage creation, sharing of information, communication. And yet, over and over again, as we will see through this talk, we see the First Amendment and copyright butting heads. And one of the themes we're going to come into is sort of when how free speech meets copyright and how those two things work together.
Right.
The only other thing I'd say on this slide is that when you're talking about plagiarism, the way I think about the distinction, plagiarism is sort of a matter of journalistic ethics to me, whereas copyright is a matter of statute and law. And so really, you need to sort of divorce your ideas about what's good journalism from what's legal in terms of copyright, because copyright can sometimes be quite technical, counterintuitive, etc. And so merely sort of trying to follow a journalistic best practices can actually lead you wrong here. And so that's one of the reasons we're hoping to sort of go through this in more detail.
Right. Yeah, copyright is like tax in only one respect. It's utterly rule-based and it is not intuitive. And your intuitive mind will take you off into the woods. Which is great for lawyers because we like to bring you back, once you wander off. So, so there are some basic rights, and you'll see this on the next couple of slides. The copyright protects certain kinds of things, certain activities. There are certain rights, and people have different sort of mental images for it. The one I've heard and use a lot is that there's like a bundle of sticks. They're different rights, and you can give away all of those rights, or you can grant them sort of one at a time, and they're sort of different. But it's the right to reproduce, make copies, the right to make derivative works. If you write a novel, a movie is a derivative work, for example, it derives. The public distribution of copies. It's one thing to make copies, it's another thing to distribute them or sell them. The right of public performance. You could write a song and then you can sing it, and there are different rights. And this goes on and on with regard to other types of works, like choreographic works, audiovisual works, public display of artworks, the very, very sort of technical performance by digital transmission of sound recordings. There's a whole industry that's set up. The performance rights organizations. It's a mammoth industry, and it's devoted just to the royalties and controlling the rights of distribution and performance.
So just one thing to note, that we had those 6 rights which were put out there. These are specifically listed out in the Copyright Act.
Section 106.
Yeah, in Section 106. One thing that you don't see up here is a right of attribution. We were just talking about plagiarism is repeating somebody else's work without giving credit. Credit is not actually a part of the copyright bundle. If you want credit for the use of your work, that's something you actually have to contract for. It's not inherent in these rights, with
A very narrow exception.
a very narrow exception.
Yes, Section 106, capital A, for certain types of works of fine art, limited prints and things like that. There is an importation from Europe of moral rights. Very narrow, not terribly well developed.
Yeah, won't apply to 99% of news reporting and things like that. So, bottom line is that if you're looking for credit on your work as it's being used by somebody else, that's something you need to think about making a deal for.
Right. So, what's copyrightable subject matter? Jeff came up with this great image. Take it away, Jeff.
Sure. So, what the Copyright Act says is that your work is entitled to copyright protection if it is an original work of authorship fixed in a tangible medium of expression. Okay, a few different ideas bundled into that. First, it has to be original. There has to be some sort of creative spark which you are contributing to its development. It doesn't have to be a large spark, but it has to be something creative and new. As courts look at whether something is creative enough, original enough to be protectable, there is a guideline they use from a case from the Supreme Court called Feist, which was essentially a phone book. The idea being that a phone book is arranged in a certain way. It's not there isn't the sufficient creativity because it's arranged in an obvious, practical manner. That arrangement was not creative enough. But really, if you are any more creative than a phone book, that's usually enough to get you over the hump. Some original idea, some original thought. It needs to be a work of authorship, so it's actually a human being who's creating it. If you've heard of the monkey selfie case, this is where you get into trouble. You actually need to have a human being involved in the creation at some stage. A crested macaque is not capable of holding copyright rights. And it needs to be fixed in a tangible medium of expression. That's an important one. We are sitting here talking. Now, if this camera were not on recording us, our words would be spoken, lost to the ages, beyond what your memories are. That's not fixed. That's just speech. Somebody singing on the sidewalk for quarters. If they're not being recorded, it's not being fixed in a tangible medium of expression. If I type it down, it's fixed because it's maintained in some sort of physical data structure. It can be electronic data, but it's in a tangible medium. Videotape, writing it down on paper, those kinds of things are fixed. This is an interesting one here. This is a photo of an ice sculpture by famed sculptor Ai Weiwei. And this is a photo I found on Flickr. It was posted by a fellow by the name of Frankie Fuganthan, who purported to offer the use of this photo under a Creative Commons license. Some of you might know what Creative Commons is. We'll talk more about that later. But basically, we had famed sculptor, ice sculpture, somebody taking a photo. Okay. Now, if this ice sculpture is south of the Arctic Circle, what is going to happen to it? It melts, right. If it melts, rots, dissolves, goes away of its own accord, gets washed away by the tide, it is not considered fixed in the tangible medium of expression. If it's going to go away in short order, it's not fixed, no copyright. This often comes up with celebrity chefs. Celebrity chefs design these elaborate plates of food and try to prevent anybody else from using their arrangement by claiming copyright in the design of the food on the plate. These claims have uniformly failed because eventually, if you leave it alone, the food will rot. So, not fixed, no copyright. However, the photograph of the ice sculpture is fixed. And there is sufficient, albeit perhaps minimal, creativity in the selection of the angle, the choice of the time of day, in terms of the taking of this picture. So Frankie Fuganthan, whoever the hell he may be, might actually have greater rights in this image than Ai Weiwei does.
And just when you thought it was safe, so there's a couple of things. Fixing the tangible medium of expression. The person taking the picture of the food, for example, has to act under the authority of the author. It can't just be anybody taking a picture of it. There has to be some sort of connection. The other thing is, and there was a case on this involving the arrangement of furniture on a front porch. It was used as an ad in an ad for an insurance company. It was, I think it was the front porch at Franklin Roosevelt's summer home, and so somebody took a picture of it. The insurance company wanted to use it, and they said, "That's great. It'll be $35,000 for this image." And they said, "We don't think so." So what they did is they found another house, and they got a bunch of furniture, and they took a picture. It looked identical. And guess what happened? The owner of the photograph, the genuine photograph, sued and won because they said it was a copy. So, like I said, your intuitive instincts will not always guide you correctly here because it's very rule-based.
Right, and we'll get to the difference between a literal copy and what is known as substantial similarity later, which is where this kind of concept gets dealt with. But you know, you can make a copy not only by direct copying.
Right. So we talk about the idea of fact expression dichotomy. Copyright protects expression. Fancy words in particular order, poetry, things like that. But ideas are not protectable. Facts by themselves are not protectable. As Jeff was saying, that there are certain things that might look like they are, created in a certain way because that they took a lot of hard work. So there's a concept known as sweat of the brow, not copyrightable subject matter, but you can have a unique arrangement of things, and then what's protectable is the arrangement, but not the things. And to give you another example of something that, again, not intuitive. There was a time that photography had been added into the statute. Photography was, believe it or not, at one point a new process. It's 175 years old. And so when it was new, it was put into the statute. And so somebody attacked that and said, well, photography in and of itself is just a mechanical process. Because in those days, all you would do is there'd be like a cover on a box, you'd take it off, and you put it back on, and the light-sensitive material would register what was going on there. It went all the way to the U.S. Supreme Court, and the vehicle for this was the portrait of the very famous author, Oscar Wilde. And it was held that the way that you set up the photograph is sufficiently creative or capable of being sufficiently creative that you protect that. You may only have a very thin layer of protectability there. You could take your Aunt Louise and pose her in the same way and take a picture of her, and that might not be a problem vis-a-vis the owner of that particular photograph. So these are very subtle concepts, and it takes a lot of exposure to these kinds of cases together. So there's some things that are deemed to be like de minimis, like we're not going to protect those. Things like headlines, although I think the headline, headless body found in topless bar from the Daily News or the New York Post, might win that. You might win that one. Or Ford to New York City dropped dead. There are some that might burst through that, but I think most things, Kavanaugh confirmed. What can you say about that, other than the stuff you can say about that?
Right.
It's not going to work. In things like titles, you might, song titles, book titles, not really copyrightable subject matter. You might have a trademark claim on some of those, but generally speaking, those aren't sufficiently robust enough.
Yeah, and there's a subtle and important issue here. This is sort of one of the first places we really see that intersection of free speech rights and copyright. Because the reason copyright does not protect ideas is because we want people to be able to exchange ideas freely. That's where the First Amendment comes in. And one of the repeated theme, which is going to come up over and over again, is that where copyright and the First Amendment intersect, if copyright would step on First Amendment rights and your ability to communicate important information with one another, generally copyright will give way. There are exceptions, this is all very nuanced, but generally copyright will give way. So, as journalists, You go out, you spend a lot of time developing facts, uncovering news, finding out things that other people don't know about. You put all of that effort in, and then somebody else sees your article, writes their own article, taking all of your hard work, and it sucks. But if they're writing their own article, changing the expression, and presenting it in a different form, the expression is different, there's no infringement. And one of the reasons why short phrases like headlines and titles and single sentences aren't protectable is that sometimes there's only so many ways you can say a particular, you can make a particular point. Tomorrow it's going to be 50 degrees in Chicago. Tomorrow in Chicago will be 50 degrees. 50 degrees is the expected temperature in Chicago tomorrow. If you granted somebody copyright protection over one of those sentences, you could wind up preventing people from talking about the weather. So
It might be okay.
right. It might improve the quality of public discourse, but at the same time, it becomes a real sort of cramp on people's ability to talk to one another.
So I'll give you an example. This is the sort of question that you might ask. Well, how long of a headline? So I don't have a good answer for you on that one, but there is a case actually involving the phrasing of the terms of redemption in a coupon for 20 cents off on frozen peas. Okay, so the next time you look at one of those coupons will probably be the first time that you've looked at it. But if you ever do that, you will see that there's a certain litany of things. You have to present it to the merchant within X days, and it's it has no intrinsic value. It's 1/50th of the cent, and all the rest of that stuff. There was actually a case on that very point, 1965, decided by the Second Circuit, called Morrissey versus Procter and Gamble, and the court said, no, that's not copyrightable because there's only one way to say that, and the variations on that are not material. And so for me, it's like 150 words. That for me is the far frontier on how far you can get away with that sort of thing. But I'm sure you can find an exception to that, right? Like a haiku, right? You probably have an original haiku, 15 syllables, 17 syllables, 52 words. So
That's where clever lawyering comes into play.
well, that's all we have is clever lawyering, folks. But anyway,
So shall we go on and talk about authors?
authors, yeah.
Okay.
Go ahead.
Okay, so the Copyright Act recognizes different kinds of authors, and an author under the terms of the Copyright Act is anybody who creates a creative work. It includes sculptors, it includes painters, it includes videographers, it includes journalists, not just your typical written word kind of creator. The three types of author recognized under the Act are the ones which are shown up here. There's what's known as a single author. That's the easy one. Somebody working alone, creating a copyrightable work. Then there is what is known as a work for hire. Okay, most of you have probably come across this term. It is a very specific term in the Copyright Act itself. There are two types of work for hire. First, if you are an employee whose job involves in creating creative works in the course of your employment, your employer is deemed the author of those works. You are never the author. From the beginning, your employer owns those works. It isn't a matter of you owning it and transferring it to your employer. Your employer simply is the author. The other form involves freelancers, commissioned works. If you are not an employee and you are commissioned to create a work, and the contract says specifically in writing, what you create will be a work for hire, it is treated as if you were an employee, and again, the commissioning party, the hiring party automatically is treated as the author of the work. However, there must be a written agreement. It must say the words work for hire. Very often when you see these contracts, we're going to talk about things called licenses and assignments later, but these things tend to be very boot and suspenders. You'll see a contract which says this shall be treated as a work for hire. If for any reason it's not a work for hire, you're assigning the copyright over to me. If for any reason the assignment doesn't work, there's an irrevocable license, blah, 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 blah. But if it's a work for hire, what's important here, the commissioning party owns it, holds those 6 rights we talked about at the beginning.
And there are different types of works that to qualify as work for hire, like answer to a test, an atlas, an index, all sorts of really oddball things The one thing that you'll run into the most is a contribution to a collective work. So if somebody writes an article that's part of a collective work, like an article in a magazine or an article that can show up on an online publication, you're fine. There are some traps for the unwary here, and very sophisticated people have tripped over this. In the absence of in the absence of a situation where you have an employee, or if you have a non-conforming set of circumstances where you have a work for hire, you can run into trouble. So people will frequently, and you'll find this more in things like software made for hire by a code writer. They'll say, okay, well, I'll write this program for you, and then they send you a purchase order, and it just says you have the right to pay money and I have the right to cash your check, and not much else. You might think that you've purchased some deep rights in this work, and you have not. All you've purchased under the statute is a non-exclusive license. So what that means is you can't stop that software writer from selling it to your competitor across the street. Ordinarily, you're not going to care about that, but there may be times when you would. And so, just be conscious of that. I'm not saying stop the presses and call a lawyer automatically. Just be careful and be aware of what is actually happening there.
Yeah, and we'll talk about licenses and those kinds of things in a little bit. And it's important to note in that regard also that they run in two directions. There are the rights you grant, and then there are the rights you receive. So before we'll get to your question in just a question, just let me ask a quick comment. Are people able to hear me in the back? Because I know the door is open and I'm hearing them. Are you okay?
Yeah, we can hear you.
Oh, okay. Your question, sir.
Yeah, I have a reporter who also reports for another paper in town that doesn't get many readers, so I don't worry about it. But let's say he takes a picture at an event and he uses it on both of our papers, and I would like to have that picture for some reason to have ownership. Is there a way I can do that?
Absolutely.
And even though it's also run in another publication?
Well, you can obtain rights in a photo. It all depends on what rights have already been granted to other people. You can obtain ownership of the photo, but it might be subject to a license which has already been granted to another organization.
Okay.
So, and it depends on the nature of those rights. If it might well be that after acquiring it, you'd have the right to cut off the permission, so the other organization couldn't use it further. But you could
6 months.
6 months or something like that. But you couldn't, you couldn't sue them for using it before that when they had permission.
What I was thinking of is, maybe at some point they may want to do a year review publication or something where photos are owned by my company.
Right.
I don't get into problems. Also, if viewers or readers submit photographs, do those become the property of my company?
Ooh, that's a great one. Well, wait for maybe licenses and assignments.
Yeah, let's talk about that again.
The answer is it's possible to get those. Click wrap, right? You usually have people upload them, and you probably have some terms of service and things like that. We don't want to get ahead of the game here, but there are ways to do that.
We had a massive flood last year, historic proportions, and I've got a lot of photos that I don't feel like I own.
Yeah.
It would be great to be able to have them and produce them at some point down the road.
We'll just as a preview, keep the word signed writing in mind, and we'll get back to what that means in this context. Okay. Last type of author recognized by the Copyright Act is joint authorship. This is where one or more authors are working together to produce a creative work, and this is the image of the stirred paint up here. The key here is that their respective contributions blend together and they're not conceptually separable in the final product. Okay, what does that mean? Two novelists working together on a novel over the course of a year, producing a single story. They're batting ideas around. Nobody really remembers who had which idea, who came up with which character. In the end, there's one work. Nobody can really say, you can't pull that apart conceptually and figure out who owns what. That would be an example of a joint work. Not a joint work. Two authors, each contributing a chapter to an anthology. Conceptually, you could pull apart the anthology and have the chapter written by author A and the chapter written by author B. Author A would have no rights in B's chapter, author B would have no rights in A's chapter, they would not be joint authors. You're only a joint author when you get that blending together of ideas. Joint authorship is important because when you are a joint author of a work, you have the complete rights to go out and license that work, exploit that work, without the permission of your co-author.
Subject to a right of accounting.
Subject to a right of accounting. Yes, I was getting there. So your co-author has a right to know what you've done with it and how much you've earned and all of those kinds of things. But they can't stop you from going out and doing it, which is why if you're in a co-author arrangement, usually it's a good idea to have an agreement with your co-author spelling out your rights and responsibilities, so you can modify that arrangement by contract.
Lennon and McCartney, not joint authors, right? You can pull those apart, right?
Lyrics and song, conceptually
Right, words and music. Right?
Words and music.
Right. Okay, you want to?
Yeah.
This wonderful picture.
Okay, so how many people remember this photo? Okay, a few people in the room. Oscar ceremony a few years ago. Ellen DeGeneres, as host, has a phone in her hand, provided by Nokia for the ceremony. Ceremony aired on ABC. Academy of Motion Picture Arts and Sciences obviously runs the Oscars. She gathers a bunch of people together, hands the phone to Bradley Cooper, who takes this photo. And of course, you've got celebrities in the background. You've got Jennifer Lawrence and Brad Pitt, et cetera, et cetera. Who owns this photo? Who has the copyright? Anybody want to guess? Okay, so I'm sorry. First, we heard owner of the phone. That's one possibility. Bradley Cooper.
I was going to say the person who snapped the photo.
Okay.
Ellen DeGeneres.
Ellen DeGeneres. Okay. A few different concepts come into play here. First, you've got Ellen's role in selecting the people who are going to be in the photo, arranging them in the background, laying out the panoply. Okay, that's an important creative choice. You've got Bradley Cooper, also engaging in some creative activity here, albeit perhaps minimal, choosing the framing, choosing how far away to hold the phone, deciding that he didn't really care if somebody was getting cut off on the right-hand side.
There might be 6 copies of this that he threw away.
Right. So you've got some creative choices there. My take on this one, Sam, you might disagree, but I like to think of this as an example of joint authorship because the respective contributions of Ellen and Bradley Cooper are difficult to pull apart from the conceptual whole.
Right. But my guess is that Ellen DeGeneres had a contract with somebody, whether it was ABC or the Academy, possibly both. I'm going to say the Academy hired her. And there's probably something in that contract that says anything that you create, except for all the stuff that's laid out on Schedule A, is ours because we're employing you. You may have some original material that you're contributing, like maybe a stand-up routine or something like that, and you license us to use that, but it's yours and you can reuse it, okay? So I'm not sure you can ever be, unless you have, full knowledge of all the facts. I don't know that you're ever going to be able to come up with a good, complete answer, but my bet is that the best bet is the Academy and Bradley Cooper, and Bradley Cooper might actually have some sort of agreement with the Academy.
I suspect everybody who was on camera at the Oscars.
Yeah, I mean, they probably signed a release that may have, I'm going to guess that they didn't cover this because they didn't think that would happen. So,
I think this was a staged event.
well, maybe. I mean, but all I'm saying is that again, it's not intuitive.
So, okay, but before we leave this, so yes, I mean, so there's the issue of who has the rights sort of as an operation of the taking the photo, and then who has them as a result of them getting assigned onward by contract. And two important pieces. There was the issue of who owns the phone. Okay, Nokia owns the phone. Interesting question as to whether Nokia owns the actual copy that was made. And
I don't think so.
well, okay. But regardless of who owns it, there's a difference between owning the copy and holding the copyright. So, you buy a piece of art at a gallery, you own the copy. You don't get any of those rights to make copies, distribute it, etc. So your rights are restricted to ownership of that copy. That can actually be important because you can have situations where one person owns the only copy of a creative work and somebody else holds the copyright. And depending on the circumstances, again, if you might mention
Section 103.
well, you might have mentioned 103 or Section 106A, but there can be circumstances where you can actually wind up with a conflict between the owner of the copy and the copyright.
And if you don't have a headache now, you will when I'm done with this. And if you think you can then do anything with this because of all the myriad rights of publicity that are swimming around in here, think again. This is a lovely, piece of work, but it's completely unusable because there's so many different rights held by so many different people who are not likely to come together unless it's for a charity or something like that.
Except for the doctrine of fair use, which is why I have it on the screen, and we'll talk about that in a little bit. Because I'm manifestly using this for a reason completely different than it was.
Yeah, but you couldn't put this like on a mug and sell them at the airport, okay? Pretty safe.
Yeah.
There's no pre-existing contract, and who is the ultimate?
If there were no contract and this really happened outside of the auspices of being done under
Bradley and Ellen, I think.
Yeah, Bradley and Ellen would probably be joint authors because each of them contributed some creative piece to the overall work. Bradley couldn't have taken the photo without Ellen arranging the people. Ellen wouldn't have gotten the photo without Bradley, without Bradley taking the photo and choosing the exact shot.
Does Nokia have any ownership?
Probably not. They wouldn't have any ownership of the. They wouldn't have any ownership of the copyright.
They might have ownership of the physical memory in the memory chip that's inside the phone. But again, copyright distinguishes between the ownership of the physical article and the copyright. They're different. Yes?
How does it apply to historical photos? I've run into, not so much in my daily journalism, but in some history projects I've been involved in, where we wanted to use photos that are available online, but the copies of the photos are owned by the local historical society or a local museum, and they claim you cannot use those without paying us a usage fee.
Yeah,
I guess
that's free enterprise in action, right?
Yeah. I don't think they really own those copyrights, but in some cases could an estate of
But they might
It's
control.
possible.
They might control access to the physical original, and so it's it's essentially an access right as opposed to a permission to copy, if that makes sense.
Yeah, they claim they own the copyright to it.
Yeah, and it's like an art museum will say, you can't take pictures here at the Art Institute or something like that. I can't say I've ever seen anybody try to enforce that, but it's a little bit of a glitch.
I mean, and really, that's an example of something which might wind up being analyzed by us under trespass law. Your conditions of being allowed on the property or your agreement not to take
And
photographs.
you breach that by doing something with it.
So you can get convoluted rights of access attached to the physical property, but all of that is distinct from the copyright analysis.
Right, and you might ask the Historical Society to walk you through their claim of ownership, and say, let's have lunch. I'd like to understand this a little bit.
Show me how you own.
So yes,
So the same thing applied to newspaper archives. So for example, our newspaper is 126 years old. And people are always asking about our archival pictures because of the large collection. But sometimes people use them without our
okay.
So anything before 1923 is presumptively in the public domain.
So yeah, the public domain is something that anything that's created within the living memory of anybody in this room is likely not in the public domain. The main but older works very well might be antique historical photos that you're probably then getting into the public domain. One major exception to that, which I'll just mention now, works created by the federal government are automatically in the public domain and you can use them. You ever need a photograph of a federal public official, go to a US government website, find their photo. If it was created by an employee of the government, it's automatically in the public domain, no rights necessary. Yeah. There are always possibilities where you can have somebody who was commissioned from outside the government to do something, and so it can get tricky, but the broad rule is that works of the federal government are automatically in the public
The only
domain.
way we can ever get through this presentation is by not mentioning every single exception.
Right.
And there's an exception to that too.
Yeah.
No, okay.
Last thing before we leave this photo. Sometimes when I've thrown this up on the screen, people have asked about whether the people in the background have rights. Remember, it's the people creating the work, not the subject of the work. This often comes up when you're looking for permission from somebody to use a photo. Keep in mind, you're usually not looking for permission from the person in the photo, you're looking for permission from the person who took the photo. That can be difficult to figure out.
And there was a really hotly contested case involving Google and a woman by the name of Garcia that for the longest time, before the Ninth Circuit reversed it, there was a published decision that said that an actor in a film could claim copyright in their performance. And this is the baddest of bad copyright law. Nuh-uh, no. And it took, what, about 2.5 years before the Ninth Circuit finally reversed that. Somebody may try again. Again, we'll never get out of here if we keep doing it.
So what
But there's a question. There's a
okay,
nice lady
one
over
question and then we'll roll on.
What about pictures that I find on the internet?
We'll get to that.
Oh, love it.
Okay.
Oh, you can use anything that's on the internet, right?
No! Okay. You did that just to hurt
I know
the
I did.
features.
I did.
Okay. But we will talk about that because that is a major
Is this
issue.
in the public domain?
Okay. Let's talk about copyright.
Okay, registration. So registration is not absolutely necessary. I actually have a client right now, a guy who's a very successful songwriter. He's written hundreds, literally hundreds of songs. And he's kind of reaching the end of his useful life, and he's trying to gather all of his assets, and we're trying to create a trust and all this other stuff. And what he's got is he's got a lot of obligations that flowed his way from folks like BMI and ASCAP. But I made the mistake of saying, well, where are your copyright registrations? And the answer is, what? I never wanted to sue anybody. I said, okay, we'll get to that. So registration is really optional, and except it's a requirement if you want to sue someone. It's a gateway to certain remedies, but it's totally not a requirement unless you think you're going to get into a fight.
Right. And the question becomes, do you register before or after somebody infringes your work?
Right, and then what happens is you give up whatever rights to damages that you could have had prior to the time of registration. And if you're generating a lot of works, I'm not going to say that you have to do it, but you get certain breaks. If you get serial registration, you can register lots and lots of things all at one time. So newspapers and magazines, for example, have serial rights that they can register.
One payment of $85 for a collection of contributions to periodicals. It's like 750 photographs at once for $65. You can do this yourself.
You really can.
You don't need an attorney for this, and you can believe us when we're telling you that, because attorneys don't tell you don't need them.
No, my rule of thumb is if you've got someone who's gotten through their sophomore year of high school, they can do it.
Do your terms of use in a publication override copyright protection?
Well, they can impact it.
Yeah, I mean, as with any other contract, terms of use or function as a contract between you and your users. And like any other contract, they can limit your rights, they can transfer rights, you can obtain rights through terms of use. So we will talk a little bit more about how terms of use operate in a bit. But you can register works online, copyright.gov/registration. It is a relatively self-explanatory process.
Although it's really annoying. Copyright Office is really cool.
Yeah,
very bad.
They've got lots of guides online which don't always necessarily align with copyright law, so it can get kind of tricky there. One thing is that, though, as Sam mentioned, there is a waiver of certain rights that happens if you wait until somebody infringes your work in order to sue them. Generally, if you haven't registered at the time of work, if you don't register until after somebody has copied your work, you can't get what are known as statutory damages, which are sort of prefixed ranges of damages set forth in the statute. It can be hard to prove how much damage you suffer through copyright. It's hard to prove lost sales. It's hard to prove how much the infringer's profits are attributable to the infringement sometimes. The Copyright Act gives you a shortcut through that to just get what are known as these statutory damage awards, these sort of ranges of damages that the judge can decide to award.
And there is a grace period.
And there is a grace period, but it's not that long.
It's like 60 days.
Yeah. So, you know, if you wait too long, you can lose that. You can also lose your right to obtain attorney's fees. You know, if you've got a registered work that's been infringed, as part of your damages, you can, or as part of your award in the case, you can get your attorney's fees back for suing.
So I want to mention this because it's a practical problem that publishers run into. So you've probably heard of patent trolls. There are copyright trolls too. And the copyright trolls register absolutely everything. And they are represented by a handful of lawyers. I'm not going to name any names because then the libel stuff that you heard in the last hour will come to bear. And they will tell you, their lawyers will tell you, well, look, you know, if you make us sue you, you'll have to pay our fees and your fees. And I hate to say it, but they're right. So be careful. I have a pretty good nose for copyright trolls. You probably do too. You probably recognize them. And they'll do things like, you know, you have like a little thumbnail somewhere. The way they find these things is they have programs called crawlers and bots, and they just send them out, and they work while you're sleeping. And they pull back these reports, and that's why you get these crazy letters. And, you know, I don't have to tell you what, I don't have a good answer for it, but they're a unique sort of problem. That you can't ignore them because they will come after you.
Yeah. So, you know, just in terms of, if you're thinking about, do I register now, do I wait? First thing is, you can only register if you actually own the copyright, so make sure it's not a work for hire because then you shouldn't be the registrant. Has infringement already occurred or is it likely? Certain things make sense to register up front. Hollywood film studios always register the films because they know they're going to be infringed and they want those remedies available.
There's big stakes there.
There's big stakes in the incremental cost of registering them is trivial, so they go ahead and do it. If you were to register everything, every news article you wrote, even if you were doing it as a contribution, that doesn't necessarily make sense. And again, even if you don't register and even if you don't have statutory damages or attorney's fees, you still have remedies. You can get your actual damages if you didn't register before infringement. You can get injunctions. You can get an order to the infringer to stop infringing it. Yeah, and indeed, you can get a federal court order which directs the U.S. Marshals to seize all of the infringing material and destroy it. You can find videos online of U.S. Marshals taking infringing works and burning them. In order to
crushing them with bulldozers and all sorts of crazy things.
In order to take those out of the market. Okay, so we've thrown around this term infringement quite a bit. Well, but what is it?
Yeah. Well, so infringement, in its somewhat of a circular definition, is that you have violated someone's exclusive rights in a work of copyrightable subject matter. You know, whether it means that you've made copies or published it or made a derivative work from it or something like that. But what you're forbidden to do is you're forbidden to make copies. Now, copies seem simple, right? It's like you feed it in a photocopy. But you can make a copy of something without literally copying it like photographically. And in order to make a claim like that stand up, you have to prove that the defendant, the bad guy, had access to your work. Well, now if the work is published in a mass medium, that's easy. But, you know, what if it's a memoir that sat in a drawer for 50 years? A little harder. And then you have to show that that the bad guy has copied original expression and not merely ideas. You know, if it's not original, then there's no problem. So, you know, the whole idea, the whole concept of what is infringement is itself somewhat slippery. You know, do you have real, literal similarity, you know, word for word copying? Or do you have substantial similarity of copyrightable elements? There's a whole treasure trove of case law that is devoted to, well, what does it mean to actually infringe copyrightable subject matter where it's not literal? You know, things like elements of a plot, descriptions of characters. It doesn't actually have to be word for word literal copying. So, as I say, there's a lot of learning that goes into this.
Right, and so, I mean, so these terms, I mean, substantial similarity is where almost all of the complexity is. Have you copied the right elements that you're actually infringing somebody's work? Direct literal similarity. That's just a term of art for when you're literally taking, you're cutting and pasting somebody else's work and you're using it and you are using it in an unauthorized manner.
Right. Yeah, and there's no state of mind requirement. It's a strict liability kind of tort, but your state of mind can matter when you're talking about things like enhanced damages.
Right. So it doesn't matter if but you can still be sued even if you thought you had proper permission. You thought you had permission, but you talked to the wrong person. You thought you had permission, but you exceeded the scope of what that permission was. And really, state of mind does come down to, does that affect damages, not does it affect whether there's a claim.
Right. I had a case once involving our client thought they got a license to a particular song to use in the film, and they got the license to the wrong song. We settled the case in the judge's chambers the first day of the case. I mean, there was just no way. It's oops. And, the statute, there's a section of the statute that talks about innocent infringement that is neither innocent nor willful, and then willful infringement. And willful, you can get, a big number. If it's innocent, you might get away with nothing, or, $200, some sort of minimal amount.
$300, I think.
Yeah, $300. Yeah. Or I think it's $30,000 for something that's neither willful nor innocent, whatever that means. And I think, like calling the wrong guy might be, something that's neither innocent nor willful. But you've got a great hypothetical.
Yeah, so let's talk about this. This is a claim that comes up every Oscar season in one form or another. So author writes a book with, it's creative, unusual premise, viewpoint. The author submits the book to, publishing division of a major media conglomerate, gets a rejection letter, this sucks. However, what sucks more is that 3 years later, the studio division of the conglomerate releases a film which is very clearly based on the same viewpoint or premise, same sort of general idea. In fact, the film follows the general plot beats of the novel and has some very similar scenes. And then to add insult to injury, the film wins a few Oscars. Does the author have an infringement claim against the studio? I will give you a hint as to the answer of this, that virtually every year, almost this exact claim is filed against the film that wins Best Picture, in one way or another. So, what do you think?
No claim.
Okay, no claim. Usually not. There are a whole bunch of traps in here. This is just, these claims sound good on the surface, but you need to really look into each of the pieces of the steps that this went through. So, author writes a book with an unusual premise or viewpoint. Well, a premise or a viewpoint is an idea, and what does copyright protect? Expressions, not ideas. So if you just copy the viewpoint or the premise, that's not necessarily going to be, that won't be enough. Okay. You need to prove that they actually copied it. We just talked about that. They need to have access to the original. This guy submits the book to one arm of a mega corporation, and then another arm of the mega corporation produces the movie. That's usually not enough. Usually courts want to see some chain between point A and point B within the organization to show that the people who created the movie actually had access to the rejected manuscript.
We had a case where the plaintiff actually got an instruction that said, that's close enough. So don't count on that, right?
Okay. What I was about to say, this can be affected in certain circumstances, both by the level of communications between the branches. You can get circumstantial evidence depending on the specificity of the eventual copy. So, for example, if on one side the manuscript has characters with very unusual names and the same very unusual names crop up in the film version.
I'm laughing because everything you say is exactly right, but it just takes, one sorehead to spoil it. And again, I don't want this to devolve into a war story, but we had a case where a guy was at a party and he had a tape and said, well, meets Jeff here who, well, who do you work for? Well, I work for CBS Records. Really? Well, I have this great tape here, right? Well, it turns out Jeff works on the loading dock and drives a truck for CBS Records. But the judge said, well, it's certainly possible that he could have handed it off to people who were 2,000 miles away in a completely different job. We said, but Judge, there's no evidence. He said, yeah, we'll let the jury decide that.
Right. Now, that's an example. I mean,
Yeah, absolutely.
These tend to,
They skew.
yeah, they tend to skew towards saying that they want something else there. But yes, it can happen. And that's the other thing. When these things go to a jury, virtually anything can happen.
Oh my God.
That's an entirely different issue. A lot of time jury decisions are based, in copyright cases, are based on who the jury thinks is cooler. I mean, there are reasons why in major music cases you will actually see, world-renowned performers going into court and giving the jury a live performance of their,
We did that in that case.
because that's the kind of thing juries like, and they tend to be favorable towards you. Okay, going back to the hypothetical. So, okay, let's say that you do get over that burden of showing a connection between point A and point B within the organization. Okay, we're still looking at that idea expression division, and then you think about, okay, what were the scenes that were copied? It says it follows the plot beats and there were similar scenes, but what are those scenes? Some of those scenes are not going to be deemed creative enough to be protected. There are things which are known as scène faire in creative works. Those sort of general tropes which crop up over and over again are sort of the basic toolkit of storytelling. Just because your cop film has a car chase and somebody else's cop film has a car chase, that's not necessarily going to be enough. Even though it is the car chase is part of the expression in the film, it's not original enough under the circumstances. It's a general trope that might not be enough. Now, if you have a car chase with the exact same number of cars down the same streets in the same arrangement, and you start getting into the details where you get into the specifics, maybe. But again, you have to delve down deeper than that top level. And so, is it possible that there's a claim here? Possibly, but it is extraordinarily difficult to prove, and it takes a lot more than just that sort of top level, ooh, that doesn't look good.
And one of the...
It makes a great sequence of stories in LA every year.
Yeah, exactly.
No, it's absolutely right. And one of the trends that, I've sort of now been at this long enough that I can see, many years ago, things might go in a certain way, but now they're a little, computers actually have helped a lot. If you keep meticulous records of how this stuff came into the house, what the creative process was, and where it went, you will be able to negative the inferences that the jury might be willing to indulge, thinking that even though the superstar actor or singer is cool, but the studio is they're a bunch of assholes, right? And we all know that they reap where they don't sow. But one of the things that having explicit records available will make possible is that you can get over that, and if you ever have to appeal it, you'll be able to say, yeah, but the evidence, the manifest weight of the evidence was against them. But like I say, it just takes one sore head, one judge who wants, who doesn't want to grant summary judgment, who, think about it. If you're a judge, what would you rather do? Spend a lot of time reading a lot of case law, or go to the circus? You'll go to the circus. That's what a trial is, right? That's so much more fun. So that's what we're up against.
Right? And if you thought all of this was confusing, now we're on to fair use.
There's a great quote from a 1939 fair use case involving the Samuel Goldwyn studio that said that there is no more frustrating concept in all of the law than fair use. 1939.
Sorry?
I didn't catch the end of what you said.
There's no more difficult concept in the law than fair use.
Oh, fair use.
Yeah. So here we go.
Okay. So fair use, what is it? It's a complex judge-made exception to copyright that got incorporated into Section 107 of the Copyright Act. It is deeply entwined with First Amendment issues. The Supreme Court has called the idea-expression dichotomy we talked about earlier and fair use as the two bulwarks of the First Amendment in copyright. And it includes the use of somebody else's work for certain kinds of purposes. criticism, comment, news reporting, teaching, scholarship, research. Okay, that sounds exciting. You heard news reporting. That should be good, right? Well, more complicated than that. You have to be within that general realm. But then, whether or not your use is a fair use becomes a matter of a balancing test of 4 factors, none of which is determinative.
Yeah, and again, I'm going to give you a little brief historical interlude. So the concept of fair use really goes back to the early 17th century and was actually enrolled in something called the Statutes of Anne. It goes way back. It's more than 400 years old. And then, as if that were not enough, there was a case called the Folsom case that was decided, I think, in 1851 in a U.S. intermediate court that sort of took that concept and tried to boil it down. And those are really the ancestor concepts that you now see up on the screen. So this is really not new law, right? You have a lot of applications of it that are sometimes unpredictable. But the basic concept has really been around a long time. And what it essentially says is, because copyright gives you a monopoly, and again, literally, if you go back to England, you got a monopoly from the crown that allowed you to do whatever you wanted to do with this piece of work. And because monopolies are so durable and tough, the law developed these exceptions to kind of deal with how tough that monopoly was. So that's where we are.
Right, and how that manifests in the modern era is that fair use winds up becoming the tool which enables the way that cultural works, creative works, engage with our broader cultural discussion. It's about how we use references and citations to creative works in our everyday discussion, criticism, commentary, and it's very important for how we talk to one another and have a common cultural heritage, because if you couldn't rely and take pieces of these creative works and use them as part of our conversations with one another in at least some way, it could really chill a cultural development, cultural identity. But let's talk about what these 4 factors are. Purpose and character of the use, nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or the value of the copyrighted work. We're going to talk about each of these.
Wow. So somewhere in, I think, 1990 or so, somebody wrote, actually a federal judge wrote a law review article where the transformative use concept was articulated. And it had a really great run, about 20 or 25 years, and it started to peter out. But essentially, what this judge said was, you can transform something and bring it into sort of a new realm without actually depriving the original work of its value. So that means things like scholarly criticism. That's probably the simplest expression of it. Or you can have some sort of critique of a work which requires you to use substantial chunks of it in order to criticize it. So, and what it does is it gives you essentially a new product that's completely distinct and has a different market and a different value than the original.
And if you think market and saw that we had another factor that was talking about market, these factors do interact with one another.
They do.
An example I like of this is a dust jacket on a book. What is the dust jacket on? What is the picture, the artwork on a dust jacket for?
Just guide your eye when you're selling a book.
You tell the reader what's in the book, to attract the reader by making it look like an attractive product on a shelf, some very specific sort of marketing purposes. What is the purpose of a picture of a dust jacket next to a book review in a newspaper? Exactly. So you're changing the use of the artwork. Instead of using it to entice the reader, you're using it to identify the work which relates to the story. It is a transformative use. Now, what is important here is that we are talking about the reason why the creative work is being used not transforming the form of the work itself. We mentioned earlier the idea of a derivative work. Control over derivatives is part of the copyright. You wrote a book, you have the right to control people making a movie based on that book. That's a transformation of the work itself, but
To another form.
into another form. But transformative use is, are you using it for some reason other than how it was used originally?
So, and commercial versus non-commercial use, when you go through these analyses, you give merits and demerits, right? And you say, well, commercial use, yeah, you get a demerit. A non-commercial use, maybe less of a demerit.
But it's not determinative.
It's not. No, it's never determinative. And so, you look at this. Aftermath of 9/11. So 9/11 is such a huge historical event. It would be tempting to say that anything associated with it really sort of belongs to nobody, or alternatively belongs to everybody, right? And that's kind of the logical fallacy that's behind this case. There was actually a case many, many years ago involving the frames of the Zapruder Kennedy assassination film, where somebody made the same argument. They said, well, you can't talk about this historical event without using those frames of film. To which a district court judge said, yeah, sure you can. That balloon popped immediately. Didn't mean that you couldn't get a fair use defense out of it, which in that case you did. But here you've got these very compelling images, and then the question becomes, I think it was the Bergen News Record, Bergen, New Jersey News Record, had this original photograph. Then other people on the anniversary of 9/11 would show pieces of this on TV, or they'd rerun them in a magazine or something else. And the question became, is that a fair use? What do you think?
No.
Why not?
Because it's an original expression. It's being reused, and just because it's a major event, unless it's, say, the fire department taking that photograph, it's Bergen Record owns it.
That's right. And in fact, people are, is it a transformative use? Well, no. You're using it for the same kind of reason, to record what happened on that day. This actually, in this case, this specific case involved a situation, and this is the danger of interns. This is an important thing to remember. So,
Dangerous for lots of reasons. Right?
So, Judge Janine Pirro's show wanted to do something on the show's Facebook, on her Facebook page, the show's Facebook page, to commemorate 9/11. So they sent an intern out onto the internet. Two things that do not go together. And the intern found this photo. Now, this is an interesting one because it started with the photo that Sam was just talking about, but somebody had superimposed that over the photo of the Iwo Jima flag. And so you had this comparison of the firefighters with this flag, with the Iwo Jima flag in the background, and so the intern found this great photo, slapped it onto the Facebook page with the hashtag #NeverForget. And the argument here was, well, more specifically, this is transformative because we're comparing the two artworks to one another. Instead of just having that original artwork and instead of just having the firefighter photo and what it said, we're adding a layer to that communication by saying, hey, look, this is reminiscent of the heroics of the past, and these, comparing the bravery of these two groups of
Big
people.
problem with that, though.
Which was?
Somebody also had done that before.
Correct. So this wasn't an original idea that the intern came up with. This was somebody else's transformative use. All the intern added was hashtag #NeverForget. The court held that wasn't enough to make their use a fair use.
Right, and everybody now knows that Ken Rosenthal staged that picture on Mount Suribachi because the first 5 shots didn't work. But that's another story for another day.
In any event. So tricks and traps and how these things get complex depending on the levels of people. Parody.
I'm sorry, Jeff. Who was the plaintiff then in your last case? Because
The Bergen News Record.
But the Bergen Record ran the piece without the Iwo Jima.
No, they did.
So
They had run the photograph.
It was original to them.
Yeah, the photograph was original.
That was a mashup that they
Because
did.
they had originally taken the real picture.
Yeah.
Right, and had licensed it for like 7 figures. So they made
They took the real picture, and then they took then they also made the Iwo Jima copy. Can I mention one thing that I think is
Absolutely.
germane to this?
Only one?
Which is, I once, when I was at the Times, the last Concorde flight was a Concorde that basically caught on fire as it landed in Paris. And there was video that some guy took who was just driving near the airport, and there was like 3 minutes of video of this fire underneath the plane that essentially kept on going until the plane landed, and then it landed and no one got hurt, but that was the end of the Concorde. And the Times wanted to use the picture, but they didn't have a video, so all they wanted to use was one snapshot of the
One frame.
One frame of the 3-minute video. And I thought that in the end, even though it was just one frame, it was a still picture rather than that, all you could get out of the 3 minutes of the video was that there was a fire underneath the plane, and that was perfectly portrayed in the still photo. And I really thought we couldn't run that. And I don't recall whatever happened. There were lawsuits, etc., because it was a very popular photo. But I was very troubled by that.
You are jumping to the concept of the heart of the work, which we will talk about in just a couple of minutes. Okay, but before we leave purpose and character of the use, often what comes up in this context is the discussion of parody versus satire. Generally in the context when copyright lawyers are talking about this distinction, parody is where you're using an original work to comment upon the work itself. Satire is when you were using somebody else's work to comment on some social trend more generally. Remember, copyright commentary, criticism, you're more likely to have a fair use if you're using somebody else's work to comment on that work. And so just when you hear that distinction, and just because, whereas just because somebody else's work is convenient to comment on the world as a whole doesn't make your use fair use.
And in neither is the parody or satire defense an automatic ticket of admission to fair use land, which is where defendants always want to be, but it's not an automatic.
Right. So this is this case from the Supreme Court from 1994, Campbell versus Acuff Rose, involving a cover of an unauthorized cover, I should say, of Pretty Woman by Roy Orbison by the group 2 Live Crew. And
just as wholesome as Roy Orbison, right? I mean, no issue there.
Well, actually, that's an interesting point, because part of the issue was that when 2 Live Crew was doing this, part of what they were arguing, they were illustrating, was that
the wholesomeness.
Pretty Woman is actually pretty creepy, and that when done in the style of 2 Live Crew, that comes to the surface. And so the idea was that was the commentary and criticism on the original, and that this was eventually held to be a fair use, notwithstanding the fact that it was a for-profit fair use.
Well, actually what they said is it's capable of sustaining a fair use defense.
I'm sorry, yes.
And this is the hazard, again, this is so inside baseball, I'm not going to spend a lot of time on it. The hazard of getting a case not on a full record in front of the U.S. Supreme Court, it's very unusual. And they remanded it, and so obviously it all gets settled, and somebody writes a check. But the point that was made there is that under these circumstances, you could make out a case for fair use if you had all of the various elements.
Notwithstanding the fact that it was a for-profit use.
Right.
Okay, another example. Some of you might be familiar with this, hopefully.
I said what in the butt. I said what in the butt. I said what in the butt. I said what in the butt.
Okay, that is a clip from a longer YouTube video posted by a fellow by the name of Samwell, which went viral for various reasons, and
none of which we have to get into.
None of which we're going to get into, which was then noted by the folks at South Park who produced this.
I said what in the butt. I said what in the butt. I said what in the butt. I said what.
Okay.
Much more charming, wouldn't you?
Samwell and his producers of South Park for copyright infringement, saying you ripped us off. This went up to the U.S. Court of Appeals for the 7th Circuit here in Illinois. 3 federal appeals court judges sitting in a room somewhere watching those clips over and over and over again and came up with this decision. When the two works in the case are viewed side by side, the South Park episode is clearly a parody of the original What in the Butt video, providing commentary on the ridiculousness of the original video and the viral nature of certain YouTube videos.
The faster you read that, the more sense it makes. Because I don't think it makes any sense at all.
It's kind of tough to figure out exactly what the commentary was that South Park was making about the original video, right? I mean, it's not like they conveyed a specific message. But one of the things to keep in mind is that, you know, you can have criticism or commentary even if the criticism or commentary is a little vague. And that's kind of the point here. It's like, was there a sufficient communication of criticism or commentary? And, you know, what's often called the fifth factor also came into play here, which, you know, is it funny? Judges have a soft spot for things which actually make them laugh.
Well, and actually, there's another angle on thank you for bringing up the fifth factor. You know, it's like the fourth wall in theater. But you know, it's like you look behind the screen, right? And if there's something like ooky going on, it won't be a fair use. And if it's something, you know, luminous, then you know, maybe it'll be a fair use. Don't overlook the fifth factor.
Okay, but still, we just got to factor two. Luckily, some of the rest of these go more quickly. Factor one is a big factor, and so we want to spend more time on it. Factor two, the nature of the copyrighted work, is sort of a minor factor. Usually where factor two comes into play in the analysis is when you're looking at, is the use transformative? You need to look at what the original work is and how it was being used. There is a trend in the law which says that works that are more factual receive less protection against a fair use claim. People copying news stories tend to do a little bit better with fair use claims because there's that danger that you're using copyright to suppress the transmission of information. But there's no preference based on quality. Bad art, good art, doesn't matter. It's, you know, that's not what we're looking at in terms of the nature of the work.
And I wouldn't use the South Park case as a way of establishing that factor. Because, you know, clearly that was part of it. But yeah, the way I would say it is fictional works have a better chance of rebuffing a fair use argument. Slightly better.
Okay. Factor three, amount of the portion used. Here you're talking about there's a question. Are you talking about the raw amount of somebody else's work that you're using or the importance of the excerpt? This gets to George's point about the single frame from the video. That's a tiny portion of the video, but it communicates the key point of that video, right? It might be a tiny fraction percentage-wise, but it's you'd call it the heart of the work. It displays the important thing, which is the fire underneath the plane. And this is what the Supreme Court said on this. The larger the amount or the more important the part of the original that's copied, the greater the likelihood that the secondary work might serve as an effectively competing substitute for the original.
So it's qualitative, not quantitative.
Right. But it will take both the literal amount and the the sort of conceptual amount into consideration. And that works very closely with the fourth factor, which is the effect on the market for the original. Does the copy substitute for the original in the marketplace? Does my use mean that nobody, of Sam's work, mean that people aren't going to buy Sam's work? He's going to be deprived of the benefits of his copyright because mine is substituting for it. If I'm a film critic and I decide that the only way for me to communicate my film criticism to you is to show you his entire movie, and so you don't need to see his film because you can watch it on my website and then get my commentary on top of it. I have now substituted for his film in the market.
Right. Yeah, and that's distinct from the movies where the trailer has all the good stuff in the movie. But it's not that different.
Yeah.
And actually, the next slide kind of illustrates this, the Jerry Ford case.
Sure. So, short form, because I know we're getting towards the end and I've got a couple of other concepts. Gerald Ford's autobiography, A Time to Heal. There is only one reason why anybody in their right mind would want to read Gerald Ford's autobiography.
No more than one.
No more than one. And that is, why did Gerald Ford pardon Richard Nixon? Well, the nation got a hold there are some complicated licensing arrangements here, but the nation got a hold of the excerpt of the book, which actually included that explanation.
Actually, they got the whole manuscript. No, there's a whole folklore. George, you may know this story. That Victor Navasky hears a knock on the door. He's the editor of The Nation magazine. Opens the door. There's no one there. A large brown envelope falls down in front of him, and in it is the galley of the entire flipping book. He stays up all night and reads the book. Okay?
And finds the excerpt where, and so the nation doesn't run the whole manuscript. They don't try to publish substantial portions. But because they deem it newsworthy, they do run the portion where Gerald Ford explains the pardon. This eventually goes to the Supreme Court on a claim of copyright infringement. And the Supreme Court said, yeah, you took a tiny portion of this huge book, but it was the heart of the work. You copied the expression. That's enough to interfere with the market for the original. This is not a fair use. Now,
it was 300 words out of a 71,000 word manuscript.
Yes.
Reporter goes to an event, is the only reporter there, covers comments of a specific person that are newsworthy, publishes a story. Other publications of say, a national nature pick up on this. They didn't send a reporter, didn't invest the time. The crux of the value is the comment that is newsworthy. Turn around a story using that comment.
Okay, the reporter didn't create the comment.
It's not original.
Any originality would have been in the speaker who provided the comment, not the journalist. The journalist's work. I mean, the journalist's creativity is in how that comment is presented, not the words
It's
selected.
the sweat of the brow. It's hard work.
Go back to the previous slide. Considers not only the market for the original work, but also positive derivative work. So
Yeah, but you got to go 17 slides back for original.
Because it's not because you have to.
So it's still plagiarism.
It might still be plagiarism, but
It
it's
might
not,
be bad manners, but it's not copyright.
It might be bad journalism, but it's not necessarily copyright infringement.
So that's the crux of a lot of discussions.
Absolutely.
That is the crux of it, right?
Yeah,
Absolutely.
and that precise point that copyright does not protect sweat of the brow is what is why copyright infringement generally isn't the cause of action you're looking at here. Okay.
So we have a few more things.
Yeah. Okay. So just really quickly, let's talk about some specific things involving the digital world. We've mentioned licenses and assignments. Fair use. If you can claim that your use of somebody else's work is a fair use, great. But sometimes it's easier just to get permission. And a permission in this context is what we call a license. Licenses are essentially structured permissions for you to use somebody else's work. There are lots of different kinds of works. There are lots of different kinds of licenses. You can sculpt them in all different kinds of ways. You can have exclusive licenses. I give you the permission to use my work and nobody else can use it. You can have a non-exclusive license. You can use it, but that leaves me free to let somebody else use it too. You can sculpt them in terms of the time. You can use it for 6 months. Format, you can use this in digital but not in print. You can, geographic location. You can use my work in the United States but not in Europe, or you can use it in New York but not in Texas. So basically, most ways you can think of to sort of carve up, structure those kind of permissions in a contract, you can give permission tailored in that way. License, that's a license. What's an assignment? An assignment is when you transfer the actual copyright to somebody else. They become the author for the purposes of claims going forward. An assignment has to be in writing. A license doesn't, although it's usually better if it's in writing, because it spells out specifically what the party's understanding is. But once you assign your work to somebody else, assign the copyright to somebody else, they can stop you from using it. You have given up your rights. Now you can assign pieces of you can theoretically split up pieces of this, and so different people can hold different. Somebody might hold the distribution right while somebody holds the copyright, the reproduction
the bundle
right.
of sticks, right?
Right. So you can pull apart the bundle of sticks, but once you give it away, it's as if somebody else holds it. It's subject to a couple of limitations. after a relatively lengthy period of time, there is an ability to exercise what's known as termination rights under the Copyright Act, so the original author can reclaim the rights. Some of you might recall a few years ago a battle between the original creators of Superman and the later holders of those rights, where
movie owners, right?
Yeah, the movie owners, where the creators attempted to reclaim those rights, and there was a big battle as to whether they'd done that properly within the correct time frames. So that's just a caveat to keep in mind, so that unlike work for hire, where you never hold the copyright, if you assign the copyrights, at some point you might be able to get them back.
Right. A termination right has a specific carve-out for work for hire. It's a work for hire, never shows up.
Okay, so how do you get permission if you want to use somebody else's work? Well, say you're writing an article about the dog days of summer, and you need a picture of ice cream to, and unfortunately the woman who asked this question has left. You need a picture of ice cream to illustrate your article. What do? Well, you go on Google Images and you search, and you find that the top row second from the right is exactly right. So you right-click, copy, send it off to your art desk, or just slap it into the article yourself if you're on your own.
And the troll will catch you.
Yeah. Are you okay? No. Good. Thank you. Why? Just because something is online doesn't mean you have permission to use it. Just because your browser allows you to do something doesn't mean that it's legal. You can copy a whole lot of things that you don't have permission to copy because of how your computer operates. But technology is not bound by copyright law. You are. So, just because you find something online doesn't mean you can use it. This comes up. So, what about social media? Okay. Social media is about sharing. People post things to the internet. People post things to social media. Doesn't that mean they're giving everybody else permission to use them? No. Okay. A photographer by the name of Morrell, I'm going to do this really short form, had a photo which appeared on Twitter. Agence France Presse, AFP, found the photo on Twitter, said, great, this person shared it on social media, we can use it, ran it. Morrell sues. AFP says, Twitter's terms of service say that you're giving them all kinds of rights when you post things on Twitter, so you've given up your rights to stop us. Court says, Twitter's terms of service protect who? Twitter, not third-party users. Twitter might have a license to distribute this, publish it, share it with other people. That doesn't give other users the right to take whatever they find. And this, again, resulted in, was it a 7 or an 8-figure judgment? It was a huge judgment. Yeah, 7 figures in favor of the photographer. Yes?
What about Facebook? A lot of us will find a photo of somebody, like maybe from just looking for a photo of somebody, right? And we find it on Facebook.
Same issue.
It's a mess.
So we can't do it without permission.
Well, I mean, if you can't do it without permission, if you can't get a license, you have to think about a fair use defense or some other kind of.
So Judge Kavanaugh's high school yearbook picture posted on Facebook. I'd say take a shot, right?
Because that's probably a fair use. You're probably not going to get that anywhere else.
It's a public figure, or is that the right? Just because it's been out there.
Because it's a transformative use. You're using it for a different purpose than the yearbook used it, and other kinds of social utility purposes come into play there.
I'd rather defend that one than the ice cream one.
Yeah.
Usually it comes up where, let's say, a student at a local high school dies.
Yeah.
Yep.
And you can't get in to get the yearbook. It's a Saturday night when you find out about it. But you can get 1,000 pictures of the kid on his Facebook page.
Yeah. There are a couple of ways to handle that one. There is the fair use argument. That's the only way to get a photo. It's important for us to be able to identify who we're talking about, and so we have to use this. That's a fair use argument. Something that some people do is say, and here's what his social media presence looked like. And so instead of just taking the photo, they will take a shot of his
broader frame,
the broader frame of the Facebook page, and that will actually be the story. And that's arguably a transformative use because you're showing it, you're recontextualizing the photo. You're making the photo is the story in a way.
Okay.
So,
yeah, a perfect example, in illustrating fair use is if you can't get the material and it's a substitute, that's like a demerit on the fair use thing. You've seen this, like a talking head newscaster has 5 newspapers on their desk in front of them, and they start holding up, here's the nature of the news coverage. No problem, fair use, you win. But if you fill the frame with the picture, like the 9/11 picture, as a substitute for material you couldn't get on your own, you're going to lose that one, right? It's a subtle but important distinction.
Wow.
What about embed? So it sounds to me like every photo on social media is embeddable.
We're going to talk about embedding in a minute.
Unless somebody takes the step of not disabling the embedding.
Well,
unusual.
yeah, we'll talk about embedding because there's some special issues that come up there. Okay, again, quickly because we're technically over time. Creative Commons, open licensing, creators put their things out to the world. It's a form of license. It's a form of contract. You can actually go on the Creative Commons website and see the exact terms you're agreeing to by using somebody else's Creative Commons work.
Open source for pictures.
Right, but it's basically, actually for other kinds of works too, but it's a contract between the creator and lots of people as opposed to just one person. Important caveat, you have to make sure that the person who's claiming to put a Creative Commons license on something has the rights to do so. I found this on Flickr. Somebody named Mark Anderson purported to offer this to the world under a CC BY license, that's an attribution license. What's wrong with that? It's very clearly not his work, right? He might have taken the photo of this card, but you look down in the corner and you see copyright 1976 Marvel Comics.
You'll blow up on the next slide.
Yeah, it's...
a couple slides.
Yeah, but in any event, so when you're looking to see about using Creative Commons stuff, look for the red flags that suggest that the person who's offering it doesn't necessarily have the rights that they're offering you. Because remember, copyright liability is a strict liability tort. Innocence is not a defense. So, it's on you if you don't ask the right person for permission. Okay, embeds and frames. Quickly, yes. And when you embed something, you're not literally making a copy. You are putting technologically a window on your website, so you're seeing somebody else's website. So if you're not making a copy, can you infringe the copyright rights? Well, maybe not the right to make copies, the right to duplicate. But there is a case out there involving an embed talking about the public display right. This is a photo of Danny Ainge and Tom Brady walking around on Long Island, which the photographer posted to Snapchat. It made its way to Twitter with lots of commentary suggesting that the Celtics were attempting to use Tom Brady to recruit Kevin Durant, I think. And so...
I'm lost.
Yeah, so this is on Twitter. News sites pick it up all over the place, embed the tweets. So they're actually embedding. They're not literally copying the photo. They're embedding the tweet on their site as part of the news. And part of what they're saying is, and here's all the chatter on Twitter about this. See what they're saying about this.
It's an event. It's an event in and of itself.
Right. Goldman, the photographer, sues all of these news organizations. The news organizations say, we didn't make a copy. It's, so we're not infringing your reproduction right. The photographer says, I'm not talking about my reproduction right, I'm talking about my public display right. You're making this available for other people to see in a way I didn't authorize. And indeed, if you go back to Twitter's terms of service, well, first of all, he didn't post it to Twitter, he posted it to Snapchat. Somebody else copied it to Twitter. So he never agreed to Twitter's terms of service. Even if he had Twitter's terms of service, if you look through them, don't give other people permission to embed. It creates the possibility for embedding, but it doesn't necessarily grant somebody rights to do these kinds of things. The court said, there is a potential claim here for violation of the public display right. This, possibly it's a fair use, possibly there are other defenses, but no, you can't claim that it isn't public, that you can't claim that you're not publicly displaying the work without permission. This sent news organizations into a tizzy, because that was one of the key ways they were getting artwork without permission, by embedding these photos. This case is still in progress. The U.S. Court of Appeals for the Second Circuit denied what's called an interlocutory appeal, which means they decided not to step in to rule on what the district court did until the end of the case.
They're hoping it'll go away.
They're hoping it'll go away, but this is one that we're watching closely, specifically about the issue of embedding. Okay, and I think I'm going to drop off the last couple of slides, so in any event.
If you haven't gotten it by now, you're never going to get it.
So, in any event, yeah.
Sometimes TV stations will put their stories on, give an embed link. So I've been using that from time to time at the bottom of my stories. And if I'm using their information, I credit them with it. Of course, when my readers click on it, it gives the TV station credit for the click.
Right, and
Is
so,
that okay, because they offer the link?
well, where they're offering you the direct opportunity to embed and they hold the copyright, that's a different situation in which you're just grabbing it from a site where the original creator never authorized that behavior. So, yeah, I would say that's a different
That's a
situation.
better case.
Yeah.
This is so, this embed problem is so gnarly because it's got like 16 layers.
Yeah,
Yours has like 2.
because they offered the link, if they didn't want you to use it.
Yeah, much easier to deal with.
They're getting advertising views on it.
Well, and like you say, the economics of it drive this. They get the click
Yeah,
credit.
I don't think they'd come after me, but I just want.
They probably will.
Yeah.
And one last question.
I work with a lot of semi-professional artists, and their work braces are publication. Underneath each one, I say image copyright, the name, the date, all rights reserved. Do I have to put that under every picture? I mean, that seems safest to me.
Well, it is the safest, actually.
Okay, then I should just keep doing it.
I think so. I mean,
You adding that credit doesn't stop you if you don't have the right, it doesn't protect you if you don't have the right permissions in the first place, but presuming you do,
we're assuming that you do.
I do.
yeah,
Right.
then that's great. The one thing that becomes a real problem is if those statements are put there by the artist and you take them off.
Right.
Or if what I'm more concerned about is someone taking the picture from my website and using it someplace else, and that's.
Yeah, you can't control that. But, you've done the most you can do.
And that's what I should keep doing. All right,
Okay, so
thank you.
thank you all very much. Here's our contact information. We are going to try to roll on as quickly as possible to the next session because some of us have plane flights we need to get to this evening. So at 4:30, I know that's pretty brief, we're going to come back and talk about media insurance. Okay? Thanks, folks.
This is great.
Thank you.